The first moon oath stone cracked before Judith Aveline had fully risen from the judge's seat. Judith stood at the blackwood rail. Before her, a tenant family waited under an exile petition that would remove them from their north, holding by nightfall. The removal decree had been signed at dawn, but would take effect only when Judith surrendered the judgment seal. She could complete witness intake, not issue the ruling. Pack advocate Silver Rennick turned toward the shallow fracture. One fracture requires seal verification before oath review. Until the clerk confirms the case number, the court has contradiction, not proof. A shallow stress line did not close the circle. The presiding judge could request one exact repetition for clarification, but it would not count as a second oath. Judith looked at the steward. Repeat your last answer exactly. Clarification only. The family abandoned the north holding willingly and refused 3 lawful summons. The existing fracture deepened across the stone. The clerk entered it as a deepened preliminary fracture, not a second oath. Close the circle, Silver said. Remove the stone and verify the case seal. The clerk extinguished the oath line and placed the stone in an evidence tray. The first sworn statement in each case was bound to the case seal and copied into the oath register. A reset stone held no prior residue. Beneath a verified seal, it compared later testimony with the preserved first oath. Material conflict fractured the stone for review. The stones did not identify guilt, motive, or which statement was true. Only after the circle closed did Alpha King Ronan Cresswell descend from the dais. Judge Aveline, step outside the circle. This was the 6th delayed exile case before the Winter Allocation Council. 3 border pacts had threatened to withhold levies, while disputed holdings remained outside supply and patrol calculations. Silver lifted the decree. Land cannot be reassigned, inheritance cannot clear, and levy responsibility remains uncertain, while exile cases remain suspended. Mercy has consequences beyond the claimant. 4 cases lacked verified property inventories, Judith said. 1 witness had been paid by the proposed buyer. Another petitioner died before signing. You hear pain before law. I hear evidence before punishment. Ronan stopped beside the empty chair. Several border houses, levy officers, and registered purchasers say these delays obstruct lawful settlement. The people profiting from speed are not the whole court. The court cannot survive if every lawful delay is interpreted as refusal to rule. Then defend lawful delay. Do not cure public distrust by making evidence optional. Silver remained composed. Long grief can deepen a judge's identification with claimants until discretionary review becomes protection from consequences. Cruelty also looks decisive from a distance. Ronan's jaw tightened. Years earlier, after an inheritance dispute nearly divided 2 clans, he had stayed in Judith's chambers until dawn while she rebuilt the evidence. He had told her that mercy made the law more exact. Judith, he said, I know you have never issued a verdict without evidence. Then why are you removing me? Because visible delay is weakening Crown authority. It became personal when you used my widowhood to make careful judgment sound unstable. He did not deny the injury. You will surrender the judgment seal. Judith lifted it from its chain. You chose the appearance of strength over the work required to deserve it. She placed the seal in his palm. My husband is dead. My standards are not. Judith turned toward the tenant mother. Do not answer another question without counsel. You no longer direct this court, Silver said. No, but the right to counsel survives my removal. Ronan looked toward the chief clerk. Appoint independent counsel. The family answers nothing further until counsel is present. It was the first thing he did after taking her seat, and it was not enough. Judith remained outside the judgment line. Silver recalled the steward beneath a fresh stone. The clerk read the reset record. Prior residue cleared. Neutral oath passed. Case seal number verified. State whether the family abandoned the holding. They left by choice after refusing lawful notice. The stone fractured. Silver did not flinch. Verify the seal before any fragment is activated. A faulty reset or mismatched circle must be excluded. The clerk matched the seal number to the oath register. A second witness entered beneath another reset stone. They left by choice, after refusing lawful notice. She lowered her eyes and paused after choice exactly as the steward had. The second stone cracked. Identical wording and the same pause suggested instruction. They did not establish who had instructed them. The chief clerk verified both stones against the same case seal and opened the oath register. A fracture did not replay testimony by itself. Formal review required the verified seal, the open register, judicial authorization, and one fragment placed beside the recorded oath. Ronan authorized review. The clerk set a silver fragment beside the register. Moonlight gathered inside the broken edge. The steward's first sworn wording returned in his own voice. The family did not abandon the holding. Field officers wearing Advocate Rennick's office colors locked the north gate before dawn. The returned oath proved that the steward had sworn a materially different account 3 weeks earlier. It did not prove which account was true, why he changed it, or who supplied the repeated sentence. Silver faced Ronan. My office colors establish assignment, not the source or legality of the gate order. Seal the field warrant, patrol roster, gate lock inventory, witness logs, and property transfer file. Ronan ordered divided custody. Stay the exile, and any reassignment of the North holding until the first oath, field warrant, and property inventory are reviewed. Place both witnesses under protection, not arrest. Judith remained beyond the rail, without her seal and without her seat. The stone had preserved a contradiction. The field warrant would decide how far it reached. The first oath established that the steward had once described a forced lockout. It did not establish who issued the field warrant, whether the officers acted under valid authority, or why 2 witnesses later repeated the same denial. By morning, the North holding file lay beneath 3 custody seals: Royal Archive, Tenant Council, and Neutral Land Judge. Judith Aveline stood outside the judgment line. 21 years of casework qualified her to identify procedure. Alpha King Ronan Cresswell had not restored her authority. Pack Advocate Silver Rennick entered without escort. My office colors appear in the first oath. That justifies inspection of field authority, not treating my office as the source before the warrant is read. Ronan ordered the field packet opened. The warrant authorized closure of the North Gate for 6 hours, while livestock, grain, tools, and title papers were inventoried. It did not authorize exile or bar the family from returning. The institutional court seal was valid. It proved the parchment had passed through Moonscar Court, not that the named judge had authorized it. Judicial authority required a separate live pressure impression. "Did you sign this warrant?" Ronan asked. "No. It carries the visible face of your judicial seal and your channel number." "The visible face does. Check the pressure direction and issue time." The clerk placed Judith's archived impressions beside the warrant. Her genuine orders pressed from the lower left, leaving a crescent rise along the upper law line. The warrant pressed from the right and lacked her settling pattern. "The face was copied," Judith said. "The pressure was not mine." Silver did not object. "Authenticate the case seal separately. False personal pressure does not automatically corrupt the oath register." The registrar compared the North holding seal with the intake mark. The number, witness identities, and first oath entry matched. The case seal is authentic. The institutional entry is genuine. The named judge's authorization is not authenticated. The patrol roster named 4 process guards assigned through Silver's department. 2 had worn office colors at the gate. 1 was stationed elsewhere. The 4th line had been altered after the ink dried. "Who could amend this?" Ronan asked. "Field dispatch, duty command, or my deputy, under emergency authority." "Your personal authorization? Not required for ordinary property security." Judith studied the altered line. Then the amendment record should identify the authority used. The dispatch book contained a reference number. Its amendment slip was missing, but the night key ledger showed the field cabinet opened at the relevant hour. The key had been issued to Silver's deputy and returned by a junior clerk. "Missing paper is not proof," Silver said. "Read the corridor and lamp logs." The corridor guard recorded the deputy leaving before midnight. The lamp register showed the junior clerk working later beside a House Merowyn representative whose family was registered to acquire the holding. Why was a buyer's agent inside Field Dispatch before the warrant was served? Ronan asked. Purchasers may submit levy estimates and maintenance bonds. They may attend property bond interviews. They may not prepare witness answers or alter patrol authority. The witness logs were opened. The steward's first interview had been conducted alone by a court clerk. His second listed a Pack Advocate observer and a Merowyn estate agent. Neither witness had counsel. A preparation sheet had been clipped inside that packet and logged by the clerk who closed it. Its custody remained intact through divided review. It repeated, "They left by choice after refusing lawful notice." The same pause mark appeared after choice. The sheet carried no author's name. It was logged only as material supplied during the joint interview. "That explains the shared wording," Judith said. "It does not establish whether they were threatened, paid, or instructed to answer narrowly." Tenant counsel requested payment records and protected interviews. Ronan granted both. The gate lock inventory showed one crown iron lock issued to the patrol and returned the next morning. Its receipt described temporary security after voluntary departure. The tenant mother spoke through counsel. "We were outside when they placed it. Our winter stores were still inside." "Did you attempt to return?" the land judge asked. "3 times. The guards said the holding had passed to court protection." Silver asked, "Did any officer say I personally ordered the gate closed?" "No. No property inventory had been completed until 4 days later. By then, House Merowyn had filed a maintenance claim and paid witness travel expenses through a court-approved account. The payment matched lawful travel rates, but approval preceded the interviews and was undisclosed to tenant counsel. "Travel expenses may be lawful," Silver said. "Before or after the later statements?" Ronan asked. "Before." Judith faced him. "You removed the judge reviewing purchaser influence while the purchaser was paying witnesses through your court. I removed you before requiring this comparison. That remains your choice, even if the payments prove innocent." Ronan ordered all 6 delayed exile cases placed under divided custody. Compare them for repeated entry desks, field officers, purchasers, preparation sheets, and payment accounts. He did not return Judith's seal. The night entry register was opened. The North Gate warrant had been entered at the 9th bell under Judith Aveline's name. Field warrants could not be pre-signed or supplied later by a clerk. The issuing judge had to place live pressure while the issue bell was recorded. At that hour, Judith was 50 miles away, hearing an inheritance case. 3 independent witnesses and the hearing register confirmed her location. The institutional court entry was genuine. The judicial pressure was not hers. Ronan sealed the 9th bell clerk roster, judicial channel register, and entry desk key record under divided custody. Someone had entered a warrant through a genuine Moonscar court channel using Judith's name and a copied judicial face while she was nowhere near the court. The 9th bell record proved that Judith Aveline had not supplied the live judicial pressure on the Northgate warrant. It did not prove who entered her channel number, who copied the seal face, or whether the entry clerk knew the authorization was false. The clerk roster listed one authorized entry clerk, Oris Vale, assigned to the western desk. "I did not enter that warrant," he told the neutral land judge. Silver Rennick studied the roster. "Did you leave the desk?" "For 6 minutes. The corridor bell failed, and I reported it to the night steward." "Was the desk locked?" "Yes." "Who held the second key?" "The duty custodian." The key register named no custodian at the 9th bell. The spare key rested in a wax-counted cradle recording release bell, return interval, and authority series, not the bearer. It had been removed and returned within 12 minutes. The blank register means no custodian signed responsibility, Judith said from outside the judgment line. It does not erase the release record. Horace's absence created the opening. It did not establish whether he had been deceived, assisted the entry, or merely left at the wrong moment. Ronan Cresswell ordered the cradle, desk seal, and channel register examined separately. The desk seal was genuine. Judith's public channel number had been entered manually. The pressure plate carried a living court pulse, but not her settling rhythm. A clerk cannot create judicial pressure, Ronan said. No. But a court override can carry a warrant into the register when a judge is unavailable. Under what authority? Silver asked. Royal Emergency Chamber, Wartime Exile Command, or Acting High Judge. Each use requires a named reason and a countersignature before dawn. Neither appeared. An uncountersigned override supported provisional action only. By dawn, it could not authorize exile, title transfer, or continued exclusion. The override book contained one torn stub. Do not treat a missing stub as proof of royal involvement, Silver said. Compare the fiber, numbering, and authority mark. The archive examiner matched the torn edge. Its numbering placed the missing page on the night of the Northgate entry, inside the Royal Emergency section. Open my chamber issue records, Ronan said. The Royal Secretary objected. Those contain military and private Crown instructions. The neutral land judge and archive examiner will separate protected matters. My chamber will not decide by itself what escapes review. Judith watched him accept the first cost of the inquiry. It did not return her bench. The 6 delayed exile files were laid out side by side. 3 used the Western entry desk. 4 named officers from Silver's department. 2 listed House Merowyn as proposed purchaser. 1 involved another buyer, that is, recurrence. Not yet a common scheme. Preparation sheets appeared in 3 files. Each was logged inside a sealed official second interview packet. Custody remained intact through divided review. None named an author or identified who supplied the wording. Handwriting excluded Judith, Horace, the tenant family's first interviewer, and Silver's usual legal hand. House Merowyn's agent used similar narrow spacing, but spacing was not an individual match. The sheet was handled inside a joint interview, Judith said. Authorship remains open. The travel payments matched lawful rates. The issue was whether purchaser funding and attendance had been disclosed before witness preparation. Why was a purchaser permitted to fund witness travel through a court account? Ronan asked. The estate agent deposited a standard bond. I released expenses under property preservation rules. Did you know the witnesses would be interviewed without counsel? No. Then the defect may be disclosure, not payment, Silver said. Or the account may have made purchaser influence look ordinary, Judith replied. The patrol amendment remained harder to trace. Silver's deputy acknowledged, taking the field cabinet key at the 8th bell. I reviewed a levy schedule and returned the key to the junior clerk. Did you authorize the 4th patrol officer? No. The junior clerk said the cabinet was already open when he arrived. House Merowyn's representative waited with a maintenance bond and gate repair estimate. Who else was present? The land judge asked. A night steward wearing royal chamber grey. He had seen the uniform, not the wearer's face or badge. Judith opened a private case index. You kept copies? Ronan asked. Public docket numbers, missed deadlines, council request dates, and funding disclosures. No sealed testimony. The index could direct the court to official files, not replace them. Official files showed 9 displaced families referred to advocates. When court funding failed, Judith placed part of her widow's inheritance in a disclosed emergency council fund. The guild assigned 4 retainers. Judith chose no lawyer and controlled no argument. A judge funding representation in cases before her creates an appearance problem, even through a disclosed fund, Silver said. The guild assigned counsel. The deposits were on the docket, and I took no part in fees or strategy. The appearance existed because the Crown left a legal right, unfunded. Council delayed rulings by requesting inventories, payment disclosures, and missing witness records. Ronan looked at the files. I called this hesitation. You called missing investigation mercy, because mercy was easier to remove than your own shortage of judges. He accepted the accusation without defense. The archive examiner returned. The key cradle and surviving edge of the torn stub carried the same abbreviated emergency series mark. The Royal Chamber Register confirmed the credential class. A royal series identifies the authority claimed, Silver said. It does not identify the bearer or prove the king approved that use. The code may have been stolen or misused, Ronan replied. Its custody was still mine to secure. Neither record named the person who presented it. Ronan ordered the chamber code register, clerk access records, and key cradle evidence preserved under divided control. Someone had opened the court desk with Crown authority that Ronan's chamber had never recorded as given. The emergency series mark proved that Crown authority had been presented to release the spare desk key. It did not prove Ronan Cresswell issued the credential, that the bearer belonged to his chamber, or that the same person entered Judith Aveline's channel number. The Royal Chamber had issued 3 emergency credentials that winter. 2 remained sealed in the Crown vault. The third had been assigned during a border evacuation 6 weeks earlier and recorded as destroyed after the danger passed. Silver Rennick requested the credential register, destruction receipt, chamber steward roster, and uniform issue book. If the code was destroyed properly, the surviving series may have been copied before disposal, she said. If it was not, someone retained Crown authority after its lawful use ended. Ronan ordered the records opened under divided custody. The credential was a white metal authority plate carrying a cut series edge, registered pressure teeth, and a waxed chamber pulse channel. Fire destroyed the readable pattern, but the metal residue remained measurable. The destruction chain listed 6 steps. The plate entered a sealed furnace packet. A chamber clerk and finance officer witnessed intake and weight. A furnace officer controlled the burn. The residue cooled under seal, was weighed again, and entered the archive. The sealed packet matched the credentials' recorded pre-burn weight. After cooling, the retained metal matched the expected plate mass after wax loss. Judith remained outside the judgment line. The record proves mass, not identity. It does not prove the registered pressure teeth were on that material. The archive examiner agreed. The series edge identified the emergency family. The pressure teeth carried the authorization pattern. The chamber pulse channel showed activation through Crown authority. None survived destruction reliably. The custody chain preserved packet weight and metal residue, the examiner said. It preserved no image, mold, or mineral trace of the pressure teeth before burning. A substituted plate of equal mass could have satisfied the record. Nothing yet proved substitution. Then the destruction procedure was insufficient, Ronan said. The defect is systemic before it is personal, Silver replied. The procedure was designed to prevent reuse, not to prove years later that a particular pattern had been destroyed. The steward roster listed 4 chamber officers on evacuation duty. 3 returned their grey coats. The 4th uniform was marked smoke-damaged and sent to cleaning. It never returned. The junior clerk, who had seen someone in Royal Chamber grey near Field Dispatch, could identify no badge, face, or height. The uniform remains a visual clue, not an identification, Silver said. The broken corridor bell was examined next. Orris Vale had reported its failure 6 minutes after leaving the western desk. The night steward signed the repair notice. A bellwright found the pull cord frayed through at the wall ring. Cut or where? Ronan asked. Repeated strain preceded the final break. Either remains possible. I left because the bell failed, Orris said. I did not know the spare key would be released. Did you enter Judith's channel number before leaving? Silver asked. No. Did anyone ask which desk she used? Court staff knew it. His absence fit inside the 12-minute key interval. It neither cleared nor condemned him. After Judith's council fund entries became public, 3 border houses filed a formal ethics petition. The neutral land judge opened a separate afternoon hearing, distinct from the warrant forgery inquiry. Silva presented the objection without embellishment. A judge may not create the appearance that one class of litigant receives privately financed access before her court. The fund was disclosed, Judith said. The Advocates Guild assigned counsel. I selected no lawyer and directed no argument. Judith had recused herself from fee disputes and signed no advocate payment order. The review still examined timing, public disclosure, and possible class favoritism. A border lord said, "Her money purchased delay. My money did not purchase delay. It funded counsel who requested records your court had failed to collect." Ronan kept the proceedings separate. Her fund is subject to ethics examination. It is not an alternative explanation for forged judicial pressure. No finding in one matter will serve as proof in the other. He did not restore her seal. The 3 preparation packets were compared across the 6 exile files. Each sheet had been logged inside an official second interview packet, and custody remained intact. None named an author. 2 packets were closed by different clerks. One involved no Merowyn agent. That weakens a single buyer theory, Silva said. It strengthens review of the interview process, Judith replied. The shared wording might have come from a template, staff access, or an unidentified participant. It did not prove central coordination or that each later oath was false. The manual channel entries showed another recurrence. 3 warrants used judge numbers entered from the Western desk. One carried Judith's name. Of the other 2, one lacked a complete settling rhythm and the other lacked the required issue bell pulse. Not false yet, Silva said. Incomplete. Ronan ordered both judges examined. At sunset, the archive examiner returned to the destroyed credential file. The surviving edge of the torn override stub matched the credential recorded destroyed after the border evacuation. Its destruction receipt named a chamber clerk and the finance officer. The finance officer had witnessed sealed intake and countersigned the weight record. He had not operated the furnace or certified the pressure teeth. The same officer later approved lawful rate travel expenses from House Merowyn's court-managed bond. No record placed him inside field dispatch, the witness interviews, or the Western entry desk. The chamber clerk, who shared the destruction receipt, had not yet been examined. The overlap creates grounds for examination, not guilt, Silva said. The amounts remained lawful. The officer remained unaccused. But one administrator now touched both the destroyed Crown credential and the purchaser-funded witness expense account tied to the later testimony. The finance officer's name connected 2 administrative records. It did not prove he retained the Crown credential, knew the witness statements were prepared, or ever entered the Western desk. The neutral land judge opened the credential destruction file first. The finance officer had witnessed the sealed packet at intake and countersigned its pre-burn weight. The chamber clerk verified the serial label. A furnace officer, working alone inside the heat chamber, controlled the burn. "Did you inspect the pressure teeth before sealing the packet?" Silva Rennick asked. "No," the finance officer replied. The chamber clerk presented it already wrapped. "Did you see the plate itself?" "Only its edge through the inspection slit." Judith Aveline remained outside the judgment line. "Then he can confirm mass, packet, seal, and visible edge, not the complete credential." Ronan Cresswell ordered the chamber clerk examined separately. The clerk said the plate arrived from the royal vault in a locked sleeve. He matched the series edge to the destruction order, but no impression mold was taken before sealing. "Who prepared the sleeve?" Ronan asked. "A chamber custodian." "Named?" "The evacuation register lists the duty position, not the individual." Silva looked toward the archive examiner. "Then the custody gap begins before furnace intake. Do not place it on the finance officer merely because he appears again in a payment file." The examiner compared the pre-burn scale, post-burn residue, furnace temperature log, and archived metal sample. The total white metal mass was correct. Correct mass does not establish correct alloy, Judith said. The residue was sent for mineral testing. While it cooled, the court opened the House Merowyn bond account. The finance officer had approved travel payments at standard rates. The bond clerk had entered the purpose as witness attendance and lodging. The payment acknowledgements carried both witnesses' marks. When was tenant counsel notified? Ronan asked. After the second interviews, the clerk said. Why? The property petition was still classified as uncontested abandonment. Judith's expression remained controlled. The first oath had already described a forced lockout. That statement was under review. Review does not make the claimant invisible. Silver requested the disclosure rule. Purchaser-funded expenses were lawful if entered in the docket and disclosed before any joint interview. The bond entry appeared on the docket, but the notice line to tenant counsel was blank. The defect is non-disclosure, Silver said. Not yet bribery. And non-disclosure allowed a purchaser's agent to sit beside witnesses whose travel the purchaser had funded. Judith replied. Ronan ordered every purchaser-funded witness expense in the 6 delayed cases reviewed. Until disclosure and interview procedure were verified, no related testimony could support exile. The border houses protested. 6 unresolved holdings already weaken winter patrol commitments, one levy officer said. Ronan placed Crown reserve grain and coin against the missing levy shares. The Pax will not pay for my court's uncertainty by forcing families from disputed land. That reserve supports spring defense, the officer warned. Then the Crown carries the cost of the delay. I refused to defend when Judith imposed it lawfully. Judith looked at him. You are funding the consequence now. Yes. That does not restore the judge you removed. No. He did not ask her to soften the distinction. The 2 additional Western Desk warrants were tested next. One carried a complete institutional seal and judge number, but lacked the final settling rhythm. The other preserved a settling pattern, but no issue bell pulse. Both judges confirmed signing related property orders that week. Neither could confirm those exact warrants. Could clerks have copied partial pressure from lawful orders? Ronan asked. Surface pattern, yes, Judith said. A full live sequence, no. Then we have incomplete authorization in 3 cases, Silver said. Not one proven method. The Western Desk repair ledger showed that its pressure plate had been opened twice that winter. One repair replaced a cracked backing ring. The second changed the wax bed after a spill. Oris Vale had been present for neither repair. The repair bin, however, remained inside the clerk corridor until monthly collection. Who could access it? The land judge asked. Clerks, repair staff, night stewards, and chamber messengers. Oris answered. His broken bell report was authenticated. The night steward had received it. The 6-minute absence still fit within the 12-minute key release. You may have been sent away deliberately, Ronan said. Or I may have known exactly when to leave, Oris replied. Both remain possible. The missing grey coat led nowhere immediate. The cleaner's register showed it accepted after the evacuation, then marked destroyed for smoke damage. No destruction witness was named. Silver requested preservation of every uniform issue, repair bin collection, and furnace delivery record. The mineral examiner returned before sunset. The furnace residue contained the expected total white metal mass, but the alloy was wrong. A royal emergency credential should have contained crown silver. The residue contained ordinary quartz scrap drawn from the Western entry desk repair bin. The wrong alloy turned the credential inquiry into a search for the plate that had never entered the furnace. Mineral testing matched the residue to white metal scrap removed from the Western entry desk 2 days before the recorded destruction. The repair bin ledger showed the same mass leaving the clerk corridor in a sealed waste box. It did not name who redirected it. Silver Rennick examined the weights. Substitution occurred between chamber preparation and furnace intake. That still leaves the custodian, packet preparer, chamber clerk, finance witness, and furnace officer. Judith Aveline remained outside the judgment line, and it leaves the genuine credential available for later use. Ronan Cresswell ordered the surviving emergency series marks compared across all 6 delayed exile files. 3 carried complete or partial impressions from the same credential family. 1 was the North Holding warrant. Another involved a widow removed from an Orchard holding. The third concerned 2 brothers declared absent while serving at the Eastern Watch. The same series may have been used lawfully more than once during its active period, Silver said. Then the dates must fall before its destruction, Ronan replied. 2 did not. The credential had either survived destruction or been copied closely enough to release the spare key cradle and enter emergency authority. The court could not yet distinguish between those possibilities. Property records added another pattern. 4 of the 6 disputed estates passed into temporary Crown stewardship, then to families in the same borderland purchasing compact. House Merowyn was one member, not the only buyer. Each transfer occurred before final appeal expired. Silver's office had processed the abandonment certifications. That is institutional involvement, she said. Not proof that my staff knew the warrants were defective. Judith looked at the dates. The buyers were registered before the families lost review rights. Purchasers may file contingent interest. They may not make the outcome appear decided before testimony is complete. The land judge ordered buyer correspondence, appraisals, and abandonment certificates preserved. No title was restored. No purchaser was declared complicit. Judith requested one older file. Ronan recognized the docket number. Judith Aveline was a witness. My husband was one of the first people whose testimony changed under this procedure. Judith did not allow grief to replace sequence. Edric's first oath stated that a tenant family still occupied its cottage when field officers arrived. 3 days later, under a replacement case seal, he testified that the holding had already been abandoned. The new seal prevented comparison with the first statement. Who authorized the replacement? Ronan asked. Silver read the line. My office did, after a clerk reported contamination in the original circle. Was the contamination examined? No surviving report appears. That does not prove the seal was changed to avoid comparison, Silver said. It proves the reason cannot be verified. Judith opened a narrow packet of her husband's final case notes. You kept sealed testimony? Silver asked. No. Private references, docket numbers, line counts, and household shorthand. I did not submit them before because grief is not authentication. Ronan studied her. You carried this for years. I carried a suspicion. The court required evidence. The shorthand directed the clerk to 3 lines in the official property file, a physician debt notice, and a missing witness supplement. The supplement was found behind the appraisal schedule. Its seal remained intact. Edric wrote that his second wording was supplied during a joint interview after an officer reminded him that his treatment debt could be called before winter. The note did not identify the speaker. It recorded the sentence he had been told to use. They left by choice after refusing lawful notice. The same wording appeared in the 3 preparation sheets. Similarity establishes a recurring script, Silver said. It does not identify its author. No, but it establishes that the practice began before the present case. The physician ledger confirmed Edric's debt was suspended the day before his second statement. Authorization came through a relief account administered by the PAC Advocate's office. The payment was lawful. Its timing was unexplained. Ronan looked at Judith. Did he tell you? Only that he had signed something he could no longer live beside. The land judge authorized review of Edric's first case seal. A reset stone was keyed to the original oath register, and one fragment was placed beside it. Edric's younger voice returned. The family was still inside when the officers arrived. The buyer's surveyor was waiting at the road before any exile order had been issued. The oath did not name Silver, prove coercion, or establish that the surveyor knew the process was false. But the buyer register showed the surveyor represented the compact that later received 4 disputed estates. Judith closed the notes. This was not mercy delaying clean judgments. It was review interrupting a property pipeline. Ronan froze every transfer and ordered every displaced household located at Crown expense. Silver did not object. She looked instead at the old relief authorization. At the bottom, beneath the office code, stood her personal approval mark. Silver Rennick's approval mark proved that she had authorized Judith Aveline's debt relief. It did not prove that she supplied his second statement, threatened his treatment, or knew the same wording had entered later interview packets. The neutral land judge opened the relief ledger. Silver stood without counsel. "My office administered winter hardship accounts," she said. "I approved physician relief when clerks certified need. I did not attend Judith Aveline's interview." "Who linked the relief request to his witness file?" Ronan Cresswell asked. "A case preparation clerk." "Named?" "The routing mark belongs to my deputy's desk. The individual hand is not identified." Judith remained outside the judgment line. Was witness cooperation a lawful condition of relief? No. Could an officer have implied that it was? Yes. Silver did not soften the answer. The ledger contained 18 debt suspensions that winter. 15 had no connection to exile matters. 3 belonged to witnesses whose later statements used the same abandonment sentence. "That is a meaningful concentration," the land judge said. "It is not yet proof of a written policy," Silver replied. The 3 relief requests had passed through different clerks, but all were routed through the same case preparation desk before reaching Silver for approval. Her mark appeared only at the final financial stage. "Did you review the witness files before approving payment?" Ronan asked. No. Hardship review was separated from case advocacy to prevent legal outcomes from controlling medical aid. "A sensible separation," Judith said. "Unless someone used the gap to make relief look conditional without showing you the condition." Silver met her eyes. "That possibility now belongs in the record." The PAC advocate's deputy was recalled. He denied instructing witnesses but admitted allowing property agents to attend interviews when maintenance bonds were pending. "It reduced repeated meetings," he said. "It placed prospective buyers beside people whose homes they expected to receive," Judith replied. "They were present for bond questions, not sworn answers. The preparation sheets were inside the same packets. He had no answer that resolved the overlap." The land judge ordered Silver's deputy, the case preparation desk, and all hardship-linked witness files placed under independent review. Silver retained her title, but lost control of the 6 disputed cases. She accepted the restriction. Ronan then asked the court to clear the chamber. Judith did not move. "If what you intend concerns my office, say it on the record. It concerns your removal. Then the record is where it belongs." He held out the judgment seal. "I can suspend the decree and return you to the bench while the inquiry continues." Silver watched without expression. Judith did not take the seal. "Under what authority?" "My authority as Alpha King. The same authority that removed me because purchasers and levy officers disliked delay. I was wrong. That is an admission. It is not a safeguard." Ronan lowered his hand. "What safeguard do you require?" "Independent review of disputed exiles. Counsel funded by law, not charity. No estate transfer before appeal ends. No royal emergency override without external counter-signature. The border houses will resist all 4. They resisted evidence too. I can restore your position now and argue the reforms afterward. A private restoration would make this look like a disagreement between you and me. Families lost land because the court rewarded speed, concealed purchaser access, and let emergency authority pass without review." Her voice remained quiet. "I will not return as proof that the institution corrected itself when it has only changed its mind about one widow." Ronan looked at the seal in his palm. "What will you do?" "Find the households your court displaced. I ordered Crown officers to locate them. They may not trust Crown officers. Will they trust you? Some will. Others should not have to." Judith gathered Edric's notes and surrendered the authenticated copies to the archive clerk. She kept only the public docket index. Ronan said, "You are leaving Moonscar. I am leaving your bench. The evidence remains. The first household was found before dusk. The Orchard widow from the second credential-linked case had spent 11 months in a border work camp after her appeal deadline passed without notice. Her former home now housed a steward employed by a member of the purchasing compact. She carried no title papers. The court had retained them during temporary preservation. Ronan ordered her brought under protection and her file reopened. Judith stopped at the court doors. "Protection is not restoration." "No," he said. "Then do not announce it as mercy." He understood the correction. The archive examiner entered with one final record, a sealed schedule from Silver's case. Preparation desk. It listed the 6 disputed estates beside projected transfer dates, purchaser deposits, and witness readiness marks. The schedule had been created 3 weeks before Judith was removed. At its bottom appeared no signature from Silver. The transfer approval line had been stamped at dawn on the day Ronan signed Judith's removal decree. It carried the emergency administrative mark created by that decree. The transfer schedule did not prove that Ronan Cresswell had planned the false warrants. It proved that his removal decree had created the authority, allowing prepared transfers to move once Judith Aveline lost her seal. The emergency mark had been designed for continuity. When a judge was removed during an active property term, it permitted the PAC Advocate's Office to preserve deadlines and assign temporary stewardship until another judge took the bench. It did not authorize permanent transfer. Yet every estate on the schedule had a purchaser deposit, projected possession date, and witness readiness mark before Judith's removal became effective. Ronan read the decree again. "I gave them a bridge around the vacant bench. Judith remained outside the judgment line. You gave lawful administration a bridge. Someone used it as a road to completed outcomes." Silver Rennick requested the schedule's drafting history. The first version, created by her case preparation desk, listed only docket numbers and maintenance needs. A second added purchaser deposits. A third added witness readiness marks and projected transfer dates. Silver's deputy had authorized the final 2 revisions. Her office seal appeared on the protocol permitting purchaser agents to attend property bond interviews. "You approved the structure," Ronan said. "I approved combined interviews to reduce delay. I did not approve prepared testimony or false judicial pressure." "Did you review what your deputy added?" "No." "Did you know buyers received projected possession dates before appeals ended?" "I knew projections existed. I was told they were planning estimates." Judith looked at the schedule. "A planning estimate does not require a witness readiness mark." "No," Silver said. "It does not." The land judge separated the findings. No evidence showed that Silver copied Judith's seal, used the Crown credential, or wrote the repeated sentence. The record did show that she approved purchaser access to interviews, failed to review transfer projections issued through her office, and allowed hardship relief, testimony preparation, and property circulation to pass through adjacent desks without independent safeguards. Ronan removed her from the PAC Advocate's Office. Silver surrendered her seal. "This is administrative removal, not a criminal judgment. It will be recorded exactly that way," Ronan replied. She faced Judith. "You were right, that the process rewarded speed. That does not make every delayed case righteous. I never asked the court to assume that." Silver gave the seal to the land judge and left without escort. Ronan opened the winter allocation session to the public. He revoked the expedited exile procedure he had approved after the border unrest. Every unresolved transfer was frozen. Every estate moved before appeal expiration entered immediate possession review. The border houses objected. "You cannot restore occupied land before title review," one purchaser said. "I can prevent disputed possession from becoming permanent while review continues. And the levy deficit? The Crown will cover it." Ronan placed 3 royal hunting tracts and part of the winter reserve under temporary public administration. Revenue would fund housing, transport, council, and missing levy shares. These lands support the royal household, his treasurer warned. They will support the households my decree exposed first. Judith watched clerks write the order. You are transferring cost away from the displaced families. I am placing it on the authority that created the risk. That is repair. It is not absolution. I know. The orchard widow received the first possession order. Because another family now lawfully occupied part of her former house, Ronan restored her title papers and orchard income, then granted Crown housing until a neutral land panel divided possession. The Eastern Watch brothers returned to their holding under temporary protection. The North holding family received keys to their gate. No family was required to praise the Crown. Compensation would come from royal treasury and Crown land, not fines against unproven buyers. Innocent purchasers could submit later claims. Buyers shown to have influenced witnesses would receive nothing. You are creating enemies among the houses supporting your winter levy, the treasurer said. I created easier enemies when I removed a judge instead of defending her standards. Judith met his eyes. Do not turn me into the reason you act correctly. No, the reason is that people lost homes under my authority. At dusk, he placed the revoked exile decree, emergency code register, and his removal order beneath divided seal. I submit all three to independent review. The land judge asked who would hold permanent authority over the reopened cases. Ronan looked toward Judith. She did not step into the judgment line. The Crown cannot appoint the tribunal that will judge Crown conduct. Displaced families, the advocates, guild, land judges, and border pacts must each choose representatives. And you? Ronan asked. I will draft the limits. I will not accept a seat you can later withdraw. The Moon Oath stones remained silent. For the first time, the court had to build justice without waiting for them to break. The tribunal charter began with the power Ronan Cresswell was no longer permitted to keep. No exile judgment could pass through royal emergency authority without an external countersignature. No disputed estate could transfer before appeal expired. No acting monarch could dismiss the tribunal, replace its members, or suspend its budget by decree. Judith Aveline wrote each restriction outside the judgment line. The first draft gave 7 seats, 2 chosen by displaced households, 2 by the land judges, 1 by the Advocates Guild, 1 by the border pacts, and 1 by the public court clerks. The Crown received no seat and no deciding vote. Ronan read the charter in open court. You have excluded the authority that must enforce its orders. I excluded the authority most capable of escaping review, Judith said. The Crown may enforce. It may not control the body deciding whether Crown conduct was lawful. A border representative objected. 2 displaced claimants may enter already hostile to purchasers. And a pack representative may enter already hostile to delay, Judith replied. Independence is not the absence of interest. It is interest forced into a record where no one interest rules alone. The neutral land judge approved the structure. The Advocates Guild demanded guaranteed funding. Judith refused another charity arrangement. Council cannot depend on my inheritance, royal favor, or purchaser bonds. Tribunal funding must be fixed as a percentage of court revenue and released automatically. Ronan's treasurer warned that winter collections were already strained. Ronan signed the funding clause. My court called representation optional. That choice ends here. Judith did not thank him. The charter limited Moon Oath stone use as carefully as royal authority. A stone could compare statements only under a verified case seal. Playback required an open oath register, a recorded vote of the tribunal, and counsel for every affected household. No fracture could identify a culprit. No replay could substitute for warrants, payment records, or witness examination. Silver Rennick attended from the public benches without her pack advocate seal. You are building a court around the weaknesses exposed by these cases, she said. I am building one that records its weaknesses before someone can use them. Will prior rulings become automatically void? No. Each requires evidence. Families deserve review, not a different form of assumption. Silver accepted the answer. Selection began over 3 days. The displaced households chose the orchard widow and a retired border mason whose sons had lost their holding while serving at the Eastern Watch. The land judges selected one northern magistrate and the neutral judge already supervising custody. The Advocates Guild sent its oldest public counsel examiner. Court clerks elected a records custodian with no Western desk assignment. The border packs delayed their choice. Several houses demanded a representative tied to the purchasing compact. Others threatened to abandon winter levy negotiations if the tribunal could reopen completed transfers. Ronan answered in the allocation hall. The levy dispute will be negotiated separately. No pack may purchase immunity from review by threatening the border. 3 houses withdrew their support from his spring command. He did not alter the charter. At the final session, the 6 selected members named their 7th, a grey-haired border captain whose unit had once enforced an exile, later overturned for missing notice. Then they elected a presiding officer. Judith's name received 5 votes. She remained standing. I will not accept appointment from the Crown. You have not received one, the orchard widow said. You received ours. Judith looked toward the land judge. Can the tribunal remove its presiding officer? By 5 recorded votes, for stated cause. Can the king? No. Can I control council assignments or funding? No. Only then did Judith cross the new tribunal line. Ronan stood as she took the plain oak chair. It carried no royal wolf crest and no chain for a judgment seal. The first matter was not Silver, House Merowyn, or the finance officer. Judith called Ronan's removal decree. He submitted without privilege. The tribunal found that the decree had been legally issued under existing law, but based on incomplete delay reports and without review of the evidence, defects Judith had recorded. Its administrative mark had then enabled transfer scheduling beyond the decree's stated purpose. Legality did not erase responsibility. Ronan accepted the finding and signed permanent surrender of unilateral royal control over exile judgments. The second matter concerned the 6 original oath registers. Each case seal was authenticated. Counsel received the files. Witnesses were placed under protection. The tribunal voted to permit comparison playback at the next public session. Before adjournment, the records custodian brought Judith a narrow ledger recovered from the purchasing compact's archive. It listed no witness scripts and no forged seals. It listed 6 estates, buyer deposits, emergency access fees, and payments marked only with a crescent symbol. The same symbol appeared beside the destroyed credential's serial number. At the bottom, one final entry named, "The person authorized to collect the genuine crown plate after the border evacuation." The name belonged to Silver Rennick's former deputy. The ledger did not prove that Silver Rennick's former deputy had forged Judith Aveline's seal, used the crown credential, or ordered witnesses to change their statements. It proved that he had been authorized to collect the genuine emergency plate after the border evacuation, and that payments marked with the same crescent symbol followed 6 disputed estates into the purchasing compact. The tribunal opened the final session under 7 independent seals. Judith sat in the plain oak chair. Ronan Cresswell stood before the public benches without royal privilege. Silver attended beside counsel. Her former deputy, Maylor Venn, entered under summons rather than arrest. The records custodian read the custody chain. Maylor had collected the emergency credential from evacuation command. No return entry named him because the plate was later recorded as destroyed. The destruction packet contained Western desk scrap. The key cradle preserved the credential's emergency series mark. 3 Western desk warrants carried complete or partial impressions from that series. "Did you retain the plate?" Judith asked. "No." "Who received it?" "The chamber custodian." "Named?" The duty office. That office has no receipt. Then it was lost. Judith did not treat absence as proof. The chamber clerk testified that Maylor delivered a locked case and remained while the credential label was copied. The clerk never opened the inner sleeve. The furnace officer confirmed that the sealed packet arrived at the correct weight. The finance officer confirmed only intake mass and later approval of lawful witness travel. No record placed him at the Western desk, field dispatch, or any preparation interview. His overlap had made him a witness, not a culprit. The purchasing compact ledger showed crescent payments routed through a private account controlled by Maylor's brother-in-law. Their stated purpose was expedited maintenance, access. 4 payments matched the dates. Disputed holdings moved into temporary stewardship. House Merowyn had paid 2 fees. Other compact members paid the rest. A Merowyn representative testified through counsel. We believed the fees covered lawful inspections and winter security. Did you receive projected possession dates before appeal expired? Judith asked. Yes. The answer established benefit and reckless acceptance of an improper process. It did not prove that every buyer knew warrants were false. The tribunal authorized playback of the 6 first registered oaths. Each case seal was verified. Each oath register was opened. Counsel stood beside every affected household. 1 fragment from each fractured stone was placed against its corresponding seal. The stones returned only the first sworn wording. A steward said field officers had locked a family outside its gate. A surveyor said he had been sent before an exile order existed. A widow's neighbor said orchard tools were inventoried while the owner was still appealing. A watch officer said 2 brothers were listed absent while serving under Crown command. None of the stones named Maylor. The records did. His dispatch code appeared beside the altered 4th patrol assignment. His desk received the 3 preparation packets before closure. His emergency access number opened the case preparation archive on each date. A crescent payment cleared. Silver faced him. You placed buyers beside witnesses, receiving court-managed expenses. They had property questions. You routed relief requests through case preparation to keep families alive. Did I authorize false testimony? No. Did I authorize use of the emergency credential? No. His answers did not erase Silver's supervisory failure. They separated that failure from Maylor's operational control. The missing patrol amendment slip was recovered inside the compact ledger binding. It carried Maylor's dispatch mark, the genuine emergency series pressure, and instructions to secure the north gate before witness intake concluded. The tribunal found probable criminal misuse of Crown authority, record alteration, and coordinated interference with exile review. Maylor was remanded for trial in a separate criminal court. The tribunal did not declare guilt beyond that finding. Silver's removal became permanent for failure of supervision, undisclosed purchaser access, and inadequate separation of relief from case preparation. No evidence proved that she forged the warrant or authored the scripts. The 6 exile judgments were vacated. Families received restored title where possible, compensation where competing lawful claims existed, and permanent counsel through the tribunal fund. Buyers who paid access fees lost priority and faced individual review. Innocent purchasers retained claims against the clearing account, not displaced households. Ronan transferred additional Crown land into the compensation trust and renewed his surrender of unilateral exile authority. He also placed royal emergency credentials under external countersignature and annual archive review. He did not ask Judith to return to his court. Months later, he arrived at the tribunal archive, carrying repaired gate records from the northern holdings. I have no order for you, Judith said. I came to file evidence, then wait with the other petitioners. He did. When his turn came, Judith accepted the records and asked only what the law required. Trust did not return as a reward for confession. It returned in smaller measures: authority surrendered, costs borne, records opened, and boundaries respected. When Judith left the archive that evening, Ronan walked beside her only after she gave permission. Neither called it forgiveness. It was a beginning. They had not stolen from anyone else.